Apologize to the last witness to be called. There's no ill will intended by being the last of the black bean.
I don't mind batting cleanup, Mr. Chairman. I appreciate you allowing me the opportunity. Members, my name is Will Adams. I'm Vice President of Legislative Affairs for Texas Trial Lawyers Association, and respectfully, we're in opposition to House Bill 2301. I have listened closely to the comments and the questions and the concerns, and I'll try to make my comments pointed. It sounds to me like on the whole, we all want the same things. We want fairness, we want efficiency, and we don't want to pull doctors out of emergency rooms and exam rooms and put them into conference rooms for depositions when it's not necessary to do so. I believe that the effect of this bill, Representative Schofield, will be the opposite of that. And I'd like to talk briefly about why. As a plaintiff's personal injury trial lawyer, my job is to present my client's case to a jury. Part of that is to present the medical bills to them in a way that they can be reimbursed for those. The law requires that I present them in a form that they're proven reasonable and necessary. The PJC includes that language in it, and so that's my duty to present the evidence to a preponderance of the evidence. Under 18001, one way of doing that, the other way is with expert testimony or doctor testimony. Under 18001 allows me to have the custodian of records sign the 18001, slap it to the bills, and we serve it, and that's considered sufficient evidence as long as there's not a controverting affidavit. The language is sufficient evidence to support a finding of reasonableness and necessity. No doctor testimony is required, no experts required to be hired, no depositions are needed. There's, in effect, a presumption. And I know that we've been debating that word and what courts do with that word, but in effect, it is allowing us the opportunity without experts, without doctors, to go and say, we have sufficient evidence of this piece of evidence. What HB 2301 does is change that to evidence of, and then you put in the line that says there's no presumption. That tells the reader that we are now below the preponderance. It's just merely evidence of, not sufficient evidence. And so we go below that. It's going to force us to take doctors' depositions when it shouldn't be necessary to do so. Quickly on the other items, I don't know how to weaponize affidavits. I've never filed them. May I take 30 seconds to finish up quickly?
Wrap up, yeah.
I've never filed them with my lawsuit. I understand the concerns that have been presented this evening on that, and I think that's something that we can work on together so that there's a fairness there. Connecting it to the expert witness designation deadline doesn't take into account the situation where a plaintiff may continue their treatment well beyond that. And any plaintiff's lawyer who files their affidavits 30 days before trial risks a continuance being granted or losing the evidence. And I think that's dangerous. Finally, the deposition of the custodian, I think, is only going to run up costs to no end when considering the fact that 18001 allows the custodian to sign the affidavit, making it sufficient evidence. I apologize for taking too much time. I appreciate the committee's ear.
Appreciate you being here.
I'll answer any questions that the committee has.
Thank you for being here. Anyone else here to testify on, for, or against House Bill 2301? If not, Mr. Schofield, you want to close?